The Unlawful Activities Prevention Amendment Bill of 2019 was passed in July 2019. Now, it had made certain amendments to the original bill of 1967, like designating individual terrorists like Jaish-e-Mohammed Chief Maulana Masood Azhar and Lieutenant Hafiz Saeed. Thus, it was passed by Union Home Ministry. Now, the background can be related to its Unlawful Activities Prevention Act of 1967, which was enacted to provide more effective prevention of certain unlawful activities of individuals and associations, for dealing with terrorist activities and for matters connected therewith. Now, this said act was amended in year 2004, 8, 13, and certain provisions were added to it related to the various facets of terrorism. Now, the main objective is to make powers available for dealing with certain activities which are directed against the integrity and sovereignty of India. Now, this amendment bill of 2011 was again added, which introduced some more effective tools to prevent unlawful activities and to meet commitment made by FATF, Financial Action Task Force, which is an intergovernmental organization to combat the money laundering and terror financing. Now, this UAPA Act expands its definition of terrorist act which threats the economic security of India and thus damages its monetary stability by seizing its production, smuggling, or circulation of high-quality counterfeit currencies. Now, the definition of high quality has been laid in third schedule of Act. Presently, this the National Investigation Agency faces many difficulties in the process of investigation and prosecution of terror-related cases. With a view to overcome such difficulties faced by NIA in investigation and prosecution of terror-related cases due to certain legal infirmity. Uh, It was brought to align the domestic law with international obligations, as mandated in several conventions and Security Council resolution of the issues. Now, this will allow the central government to designate individual person as a terrorist and thus bring embargo on arms and asset seizures. Now, individual can appeal against the inclusion of his or her name and thus seek a hearing before this review committee, which is constituted by central government under Unlawful Activities Prevention Act. So remember this term, review committee. This provision is similar to the United Nations sanction, which was used by Security Council to apply pressure on a state or entity to comply with the objectives set by United Nations without resorting to the use of force. Now, the designation offers Security Councils an important instrument to enforce its decision. Now, as for the United Nations, when a person is designated as a global terrorist under the United Nations 1267 ISIL and Al-Qaeda Sanction Committee, a travel ban is imposed on the subject. Certain other features includes the amendment to the Schedule 4 of Bill, which will allow the NIA to designate an individual is suspected to have terror link as a terrorist. Now, as of now, only groups are designated as a terrorist organization. Now, this will empower the Director Generals of NIA to grant approval of seizure or to attach the property when the case is investigated by said agency. Uh, After amending the Section 35 of Act, it will empower the central government to add or remove from the proposed fourth schedule the name of an individual terrorist and other consequential amendment related thereof. It has inserted a new clause in the Bill 43 of Act, which will empower the officer of rank of Inspector of NIA to investigate the offences. Now, the government believed in zero tolerance towards terrorism, and thus a provision is needed to designate individual terrorists in law. There are certain concerns of bill. It has claimed that the number of tackling terrors, fundamental rights of individuals are foregone. Now we have no clarity on government's claim that the NIA finds it difficult to deal with such individuals at present, and it demands the government can't keep house in dark on so-called difficulties. And there are several provisions in law to go after the individual, and thus the government is failing to take pre-legislative consultations. UAPA is an Indian law which aims at effective prevention of unlawful activities associations in India. Now, its main objective was to make the power available for dealing with activities directed against the integrity and sovereignty of India. Another objective of bill was to make power available for dealing with activities directed against the integrity and sovereignty of India. This bill was passed by both the House of Parliament and received assent of the President in 1967. The amending Act are as follows. First is the Unlawful Activities Prevention Amendment Act of 1969, then Criminal Law Amendment Act of 72, Delegated Legislation Provision Amendment Act of 1986, and UAP Amendment 4812. Now, there is also another important act which is Prevention of Terrorism Act of 2002, which was found post the parliamentary attack in year 2002, and it was passed in with the objective to strengthen the anti-terrorism operations, and thus it was enacted due to several terror attacks that are carried out in India and in response to the attack on Parliament. It has represented the Prevention of Terrorism Ordinance Bill of 2001, POTO, Prevention of Terrorism Ordinance of 2001, and also the Terrorist and Disruptive Activities Prevention Act, TADA, Terrorist and Disruptive Activities Prevention Bill, TADA, of 1985 and 95. Thus, it has replaced two acts. First is the POTO and second is TADA. Now, this act has defined what constitutes a terrorist act and who a terrorist was, and thus it granted special powers to investigating authorities described under the act. So, in order to ensure the discretionary power granted to investigation agencies were not misused human rights violations are not committed. Specific safeguards were built. Now, this Prevention of Unlawful Activities Act has certain concerns and its democratic values. Now, it is said that as the second branch of government, the purpose of legislature is to make the laws which upholds the fundamental rights of citizens. But this act has made certain extraordinary circumstances. The Indian legislature has made laws that have not only regulated fundamental rights, but it has also contradicted them. They have endowed the state with access power to violate constitutionally guaranteed rights at both the individual and community level. Now, usually this unconstitutional law was designated with the protections against a threat. Now, this act has been sometimes used by separatist groups to serve their partisan interests, such as the national security law was to suspend the fundamental right and detain in the Kashmir in the name of public safety. Now, anti-terrorism law to repress the dissent, terrorist laws to target minorities and marginalized groups. Now, way forward is to have a comprehensive, non-discriminatory definition of terrorist must be defined, and those crimes which are defined under any other existing law must be removed from UAPA. The court proceedings must be open and transparent. Clear reason must be given before banning any organization, and the action against security forces misusing this law must be ensured. Now we can see in this chart that the original Unlawful Activities of Prevention Act of 1971 consider offences such as terrorist acts and the membership of terrorist organization. Now funding and supporting and recruiting terrorist organizations. Our Unlawful Activities Prevention Bill has, let's read about context once again. It was enacted to provide more effective prevention of certain unlawful activities of individuals and associations and to deal with terror activities and for matter connected therewith. Now it will designate individuals as a terrorist in Amendment Bill. Now what are the proposals of this amendment? Now as we saw earlier that as of now only the groups are designated as terrorist organization, but this amendment will allow to designate any individuals to be suspected to have terrorism as a terrorist. It will empower the central government to add or remove from proposed force schedule the name of individual terrorists and other consequences related thereafter. It will empower the Director General of National Investment Agency to grant the proposal of seizure or attachment of property during an investigation. Now it will empower an officer of rank of inspector or NIA to investigate the offences. There are certain concerns that there is no clarity on government's claim whether the NIA will find it difficult to deal with such individuals at present. Now, media, as we see in India, they claim that in the name of tackling terrorism, the fundamental rights of an individual can be foregone. Now, there are several provisions in Act to go after individuals and government in failing to take legislative consultations. What are the way forward? We must create a comprehensive and non-discriminatory definition of terrorist definition. A clear reason must be given before banning any organization. Now the court proceeding must be open and transparent, and the action against security forces misusing the law must be ensured, and those crimes which are defined under any other existing law should be removed from UAPA. Now, bottom line is that what are the controversies? First is that as the second branch of government, the purpose of legislature is to make law which upholds the fundamental rights of citizens. But however, when met with extraordinary circumstances, the Indian legislature has made laws that have not only neglected fundamental rights but have also created contradiction with them. They have endowed the state with excess power to violate constitutional guaranteed right at both the individual and community level. India's draconian laws are sometimes mobilized to serve the partisan interests as visible in certain cases. Now, although such amendment, if needed, should be brought in, but not without undergoing a wide public debate on various features of proposed amendment and their implications. So this was our Unlawful Activities Prevention Act. Thank you.